Oh, hey, what's up, everybody? It is Joey B here with the Blind Knowledge Podcast. It is 10:56 Eastern Standard Time here on the East Coast of the United States of America. Hello, Japan. Hello, Germany. Hello, Asia. Hello, Africa. Hello, DLP. If you're listening over there in Nigeria, good friends of ours here at Blind Knowledge, we have something special, something different. This has never happened before. It's huge. We have Noah Healy back for part 2 right away. So I don't know if you were with us for part 1, but the episode just dropped, so you can check it out at the Blind Knowledge Podcast. It's on Apple Podcasts, on Spotify, anywhere you listen to podcasts. Really, just type in the Blind Knowledge Podcast, and it's the last episode is Noah Healy. And it just came out. He's a genius. He's a real smart dude. And we're happy to have him. But he has part 2. Check out part 1 for the saga if you haven't heard it, though. It's patents. It's all about patents. It's wild stuff with lawsuits and like really high level Supreme Court kind of jurisdiction. I'm gonna let the man speak because I just don't want to get anything wrong here. This dude knows. Noah, what's up, man?
Hey Joe, yeah,
Hey.
it's a crazy thing, and it's been going on for actually a lot longer than I've been pursuing chord disc, and I've been wrapped up into it. I might have the craziest story in patent history, but it might just be how crazy everything is now.
Okay.
I'm just caught up in it.
Okay.
Um,
What's going on?
So the first thing I think is to sort of set the stage of what patents are and what sort of intellectual property is, just to give a sense, because people tend to think of everything working the way that like music and movies works, but those things aren't really. Uh, the way they are because of laws. They're that way because of a lot of contracts and union negotiations and so on. So there's sort of four big kinds of intellectual property,
Okay.
uh, and those are copyright, trademark, trade secrets, and patents. Um, Copyright is basically on information. So every kind of artistic expression, uh, this recording of us, anytime you write a book or an article or a list for the grocery store, those things are all copyrighted.
Okay.
Uh, Copyright used to
My
be,
list for the grocery store is copyrighted. Really?
yeah, yeah. Copyright used to be much, much more restrictive. So, for example, It's a Wonderful Life became incredibly popular because the at that time, in order to be
Heard so.
copyrighted, there had to be a copyright notice on every single instance of a copyrighted work. And one of the film reels for It's a Wonderful Life
The movie, not the
was
song. Continue.
the
Sorry.
movie, yes, was printed without that copyright notice, which meant that the entire film was
Wow.
public domain. And that allowed television stations to be able to get content by putting a Frank Capra movie on during Christmas, and so they did in abundance.
Yeah,
I
like
can,
every year, pretty much.
yeah, yeah, I can
Wow.
recall one time visiting an aunt and uncle in Fairfax, where they had a very large number of local network TV stations when I was a child. So this would have been early 80s. And we were watching It's a Wonderful Life, and some cousins came in, and we changed the channel back to another presentation of It's a Wonderful Life on a different station that was earlier so that they could watch it from the beginning. Because there were at least four different versions of It's a Wonderful Life just having started at different times, all casting at the same time. Um,
That's a lot. That's a lot
y-
of It's a Wonderful Life, Noah.
yes, yeah. Well, that's back in the 80s. That used to be what TV was like. So that's copyright. It's been
What's
changed
that?
so that it's automatic. Um, Although, if you were
Okay.
to attempt to enforce the 90 years after the author's death clause on your grocery list, you'd have to do a little bit more work than just having written it down and dropped it underneath the
Yeah,
couch
would you have to
cushions.
sign it, or would you have to say like this is copywritten, or is it just automatically copywritten because
Literally everything you create is basically automatically copywritten, but you can register copyrights, and if you intend to actually get commercial use out of them, that's a really good idea.
okay, and why? Do you know why, by any chance?
It's a good idea basically because it solves dispute issues.
Okay, so it's just a one stop shop. Here's the copyright.
Right.
End of dispute.
Yeah. So, for example,
Makes
when
sense.
J.K. Rowling was on her first book tour through America, one of the things that she found surprising, fans would come up to give her things, and there was actually somebody from the publisher that was assigned to take those things from the fans. And so after a couple hours, she asked, what's going on? Like, why can't I take things?
Why can't I get
And
close to people?
yeah, and they told her that that's a protective measure. Some of these people are going to hand you manuscripts so that they can create foundation for suing you later for infringing
Whoa,
copyright. And so, for
what?
legal reasons, we are arranging the circumstances so that you will have not received anything from anybody in order
Wow.
to basically be able to throw those cases out of court.
Right. Okay. Yeah, I follow you 100%. That's wild.
Yeah. So after copyright, one of the most prevalent parts of intellectual property is trademark.
Right,
Uh,
which is a fun one.
yeah. Uh, Trademark, unlike most forms of copyright, doesn't fall out of use, but it has to be defended. So there
Wait, their
are
lifetime or their
no, they're
total
forever.
lifetime? For they're
Um,
forever.
if you create a
Wow.
trademark, and that trademark continues to be defended by, say, your descendants or some company that you sell the trademark to,
Yeah.
then as long as they continue to defend and use that trademark and it does not pass into common usage, then it remains.
That's awesome.
This is why, for example, Google executives will never refer to Googling something, and will only refer to using the Google search function or some other fairly stylized form of
Very
address.
stylized. It sounds very
Yes.
stylized, Noah. That's
Uh,
smart. That's like so that's beyond smart. That's Google's just covering every base. That's crazy.
right. And of course, the degree to which humanity decides to use Google as a synonym for the concept of search, if it becomes generally accepted that that is the case, Google's trademark on the word Google would actually go away, because you're not allowed to trademark generally used words. So,
Okay,
for
so that
example,
part makes sense. That makes
Campbell's
sense.
couldn't trademark soup. Everyone, soup is a word that means things. Everyone's allowed to sell soup.
Yeah, but it's different. I think when I think soup, I don't just automatically think Campbell's. It's like when you think looking up search, you think Google, or maybe that's just my brain, you know.
Well, many people do, and of course, that's a large amount of Alphabet's value proposition is that people think that way. But for trademark
They probably do.
purposes, their lawyers would really prefer to sort of have their cake and eat it too.
Oh, I'm sure.
Um,
I'm sure, man. Yeah, they're Google. They have their hands in everything. I love Google. They're also just the spawn of Satan sometimes too. And I mean that in the nicest of ways. I do, because I love Google.
so the next thing is
I'll defend why I mean that too,
okay.
if you'd like. Um,
Uh,
it's just the
w-
algorithm. It's actually literally this is too funny. It's because of the algorithm, Noah, and you're the algorithm developer. It
yeah.
feels like the algorithm of Google was a lot better 3 years ago or 5 years ago, or it was easier to find the answer to my question than having to go search
Yeah,
and wonder if this is right or if I have to go through 10 survey questions. But other than that, I love Google.
yeah. I don't think they're keeping up with the increased complexity of the world that they've ushered in.
Thank you for saying that. Thank you. I agree 100%. And I'm still here. No hitman at the door yet. So me and Google are cool. So patents. Patents are a big deal. You know about patents, right?
Right.
Tell us about patents, Noah.
So patents are weird. The first and most important thing, if you're trying to get a patent, is that it can't be published. Once it's public knowledge, it's not patentable anymore.
Interesting.
Uh,
Interesting. So once it's not blind knowledge, like once it's known knowledge, you can't be
y-
patented.
yes, and when you apply for a patent, unless you pay a fee, an early part of the application process is actually publishing the patent that you're applying for. So the act of applying for a patent in a standard fashion will actually render that idea unpatentable outside of the existing scope of the thing being pursued.
Yeah, and you kind of mentioned that in the last interview too, where there's like a whole process to this patenting. Obviously, there's a process, but
Right.
yeah, I'll let you talk about it. I don't want to say the wrong things here, and then I lips are
Well,
sealed.
so yeah, there's basically two ways to get started. I've sort of done the entire soup to nuts. So I actually got started with a provisional patent application, and this is a thing that you can do to essentially establish your priority.
Okay.
It's a fairly simple form. Um, the description can be relatively vague, and you really only need to be able to draw a line from what you're describing to what your eventual patent application entails. So uh, there's some wiggle room in there. You can kind of be like, if you're in research or something like that, and you start seeing this possibility that something might be a good idea, you can file provisional patent for sort of space around the thing that you're dealing with. And then if it turns out that you got a good idea, then then you can go ahead and patent that. Um, on the other hand, if that isn't the
Sounds
case,
easier.
yeah, then you can just let it go. So a lot of provisionals get filed defensively or even offensively by major corporations in order to try to wall off areas that they are working in or want to be working in the future. And that gives you 1 year. Uh,
1 year
y-
of a provisional patent, correct?
yes, in order to file the full patent application
Okay.
without losing your priority.
Interesting. Okay.
I did a provisional basically so I could talk to people and try to find an attorney that I could actually work with.
To be like,
Uh,
okay, this is really what I have going on. This is
yeah,
where we are in the process. And if you have the provisional, does that give you first running until
yes,
patents
yes. So
expire?
that
Okay.
it
That's awesome.
establishes your
Genius.
priority, and in fact establishes when the patent begins. So that's another interesting thing. Your patent's start date starts at the time that you file the patent, but the force of your patent doesn't start until after your patent is accepted. And
Okay. And
since
they take a long time, don't they? I'm
about three
guessing.
years
Oh, Jesus.
from filing of the
That is
from filing
ridiculous.
of the patent application, which if you filed a provisional, waited a year, and then filed a patent application, that could be 4 years.
3 to 4 years. That's wild. That
Yes,
that's
yes, that's
that's
just that's we're getting the first tastes of just how crazy
so you've been
things
waiting
are
3 years, and
in
then all
patent world.
this. You've been waiting 3 years, and then all these things have just been happening, basically.
More or less, yeah.
All right, well, tell everybody about it. What's been happening?
So once you file your patent application, again, unless you file a fee in order to speed things up, it takes them 6 months to assign a patent examiner to it. And this is the person that you're going to have to convince that you should get a patent. At the time of the assignment, that is when they actually publish on their website your patent application. So for me, this was 18 months into the process. And then
Okay.
part of that process is deciding what division of the patent office this actually belongs to. So, for example, if you invent a new part for cars, that wouldn't be, be, being looked at by a civil engineer.
That
It'd
makes
be
sense.
looked at by some sort of automotive engineer.
Different specialist. Yep.
So the different departments have different sort of, you know, backed upness. It ranges from 24 to 36 months on average for each different department. The zone I was in, which was sort of these financial business process patents, has a 32-month waiting time.
32 months. Okay. Well, it's been a long time. Obviously, you've been sitting waiting. I don't know. What do you do? Probably not thinking about it. I'm guessing.
So
Um,
I was working on some other things. I also picked up a day job in order to be able to keep going. Uh, but
that's what's up. That makes sense.
but then you get what's known as your first office action, and there's a sort of a dance that the patent office and lawyers have established. Um, a copyright is a relatively specific thing. Um, Again, Harry Potter's very famous. You could write another story about a boy wizard. I mean, Harry Potter was not the first childhood coming of age wizard story by a long stretch. And there's been a lot that have come out since Harry Potter came out. And if you wanted to write another one, you could not, go for it. But with a patent, you sort of want to build a fence around your idea so that people can't lightly tweak it and get and encroach
And
upon
take
what
your
you're doing.
idea. Yeah,
Exactly.
sure. You have your certain. There's certain parts of that are yours. Absolutely.
So that gets quite tricky, um, because obviously you would like to take as much as possible, and the patent office would like to grant you as little as possible. And so there's sort of a negotiation there. And so the kind of established dance is that in your claims, your what you do is sort of in your first claim you claim sort of everything, the entire universe, and then you narrow down your claims until you get down to the claims that are actually regarding your actual patent, which again you try to stretch as broadly as possible. um, so for example, there's a pretty famous book, and I'm not going to be able to remember the name because I read it more than 5 years ago now. But it was written by IBM's chief patent lawyer, and uh, it's sort of the Bible in sort of how patents work. And if people are interested in IP, I'd strongly recommend taking a look at it. Um, and hopefully that's enough information to find it. That's sort of how I found it.
Yeah, I was trying to help you out. No, I'm looking for it right now. Was it above the law? No.
I don't think
Yeah.
so.
All right. Never mind. I'll find it for everybody.
Yeah, I don't think Steven Seagal does patents.
No, it does. I believe that checks out. I'll Google it and find out though.
That's right. Um, so uh, what you do is you sort of write this massively overbroad patent that still contains your actual claims. The patent office disallows that patent for being overly broad, but says, these are good claims. And then you rewrite the broad claims as dependent clauses of your actual claims. So you wouldn't claim sort of like a ballpoint pen, you would claim sort of every universe that could contain ballpoint pens, which are this specific thing. So that gives
Okay.
you your
Okay.
very wide fence that's still actually constrained to your actual idea. And this is where I kind of stepped on their toes, because the claim language in my patent was too specific. So the the attorneys had included several integral equation formulas that described possible implementations of a CDM, and I had stressed to them that these were, single possibilities, but not the complete set of possibilities.
Do you say that in paperwork, or do you say that like vocally? Is there like a hearing kind of thing?
So I'm talking to my attorneys, so that
Oh,
was
okay.
expressed
That
through
makes sense.
phone calls and emails with them.
Gotcha. And then they vouch
and
for
then
obviously
and
the
then the patent
validity.
application that they actually write, that's paperwork, and that patent application, that first one, is in fact still publicly available on the the website. There's a
Where
very
where where can I pull it up?
ooh let me see if I can. Let me see, I've got so is there some, like, a chat or something?
Yes,
Yes, here we
sir.
go.
It is on the.
It's going to be quite a link.
That is quite the link. That is the quickest link pick I've seen in a while. Here we go. All right. Welcome to Patent Public Search. I'm just gonna throw this bad boy up here. Wow. peepubs.uspto.gov. Okay. All right. So what do I search for? Do we know?
Oh, darn it, they
This
broke
is
this link.
interesting.
Um,
Oh, we have an old school query. The database system. But anyway, we don't have time to
yeah,
do
I'm
this.
I'm not going to be
No
able to
worries.
find this in time. I'm sorry.
Okay, I'll mess
I'll
with
have
it.
to
Maybe we'll get it later. No worries.
I'll have
We
to
got
look
it.
that one up. Noah
All right.
Healy might be able to find it. I do have one other patent I got for somebody else.
All right. All right. So anyway,
So at any rate,
we have that.
I kind of
So
stepped
what?
out of the dance at that point and made them not just do the thing that you normally do to get your patent and continue to spread the language. So we had to go back and forth a couple of times. The other thing that's quite common is that the patent office will claim prior art. They'll basically just say, "There's nothing new under the sun. Here's some stuff that is your idea." And in general, what they do, according to the people I've spoken to, and certainly this happened to me, is they'll find some keywords in your patent. In my case, one of the critical ones was parimutuel, um, and get some patents that reference that keyword and are just books. So they came up with something that they referred to as the Lang patent. It was three guys, and they effectively patented every single kind of parimutuel betting scheme that they could imagine. Uh, their patent was eventually bought by the Hong Kong Jockey Club and the CME Group, but the patent application itself was hundreds of pages long, and it's essentially all a scholarly mathematical work on the properties of parimutuel systems. Um,
Okay.
and that's where I had to step in with my expertise and demonstrate why my patent was not treading on their patent. And this is actually something that's
Oh, I see.
technically useful for people to know. There's a concept called teaching away. So, if in the course of describing the limits of your patent, you are specifically excluding uh, something, then then other claims, other patents that are referring to that thing that you're teaching away from are sort of automatically excluded. So imagine a world where tables didn't exist and you were patenting tables for the first time. And in the course of describing what a table was, you pointed out that one of the key, like properties of a table is that it had four legs, because obviously tables couldn't have any number of legs other than four. Um,
What?
if a second person were to then come in and patent a three-legged, two-legged, one-legged, five-legged, six-legged tables, then they would be able to invalidate exactly. They would be able to invalidate your patent as prior art because you were teaching away from the concept of non-four-legged tables.
So it requires its own patent because of that. So it
Well, yeah,
obviously.
except tables, had all pretty much completely pre-existed. It would be very difficult, probably, to come up with a relevant table patent in this day and age that
Oh,
wouldn't be covered
imagine
by.
imagine how many people over the years have sent in patents on like that, like a table. Like trying to think of different ways to put the table on the wall, next to the wall, on the ceiling, held up by gravity. I bet you one of those is in there. That probably got canned
Have you
way
seen
ago.
tensegrity?
Oh, no, I have not. No.
So tensegrity is a trick where you can basically take chains in opposition from two things so that something is essentially being held up through tension rather than compression. And it, people design tables using, yep, that's what they look like. So you can see in that first image there, there's sort of two hooks that each have chains from them. There's no solid connection from the floor to the ground. Um, it's simply all done through tension.
That's wild. Look at that. That's probably no thicker than an E string on a guitar.
It might be a little bit thicker than that. For real fun, because this is all based on attraction, you could actually use magnets to do that as well. And so you could create a completely touchless system if you had powerful enough and well enough aligned magnets.
All right, we're getting wacky now. This is the. Wait a minute. Magnet tables touchless target. This is what I'm talking about. Noah,
Suddenly, Google has decided that you need to be looking at some ads.
Noah, this is what I'm talking about with Google. Look at this. Someone's probably listening. No, but that is weird that happened. I put in magnet tables touchless and target. Anyway, all right, we've gone off track here with tables. We've
Yes.
gone all over the place. Let's refresh. You've had
So
a
at any
long,
rate,
yeah, no, you've had a long struggle with this patenting. It can take up to 32 months with your actual category of patents. You have, done
so
everything you needed to do after 18 months. Something happened. Go for it. No, you got it. I was just trying to
yes,
get
just
a
keep
summary
us.
for you.
So that's where we are. So I'm looking through the Lang patent, which is hundreds of pages of mathematics describing the structure of every possible uh, parimutuel system that they can imagine. Um, there are two saving graces. One, and I believe it was section 8 of the patent, they point out that their system only works for up to countably infinite uh, pool sets for the parimutuel system. So this gets into a branch of mathematics that was started in the 19th century, Cantor set theory, where mathematics decided that infinity was actually an interesting structure, and that there were different levels and sizes of infinities, um, and that
No,
countable infinity was the smallest one.
no, I'm here, but I gotta stretch out because that's crazy. You said there's multiple infinities.
Yes, yes,
Oh
there's
no,
more
I gotta
than the
walk away.
infinite number that you're thinking about of infinities, in fact.
My brain just exploded.
It has that effect on some people. So they were claiming every single set of parimutuel games where there was up to an infinite number of outcomes possible. So they
No, I'm
figured
listening. My brain just got
they had everything covered. My system is
ugh.
actually working in functional space, which belongs to a few orders up of infinity from countable. So I
Okay.
was explicitly dealing with a larger scale of infinity than they were dealing with. So that teaching away thing kicks in.
That's
And as a
wild.
result of essentially one sentence in this over 500 page long patent, it was completely invalidated. Uh,
Because of a bigger definition of infinity.
yes. The other fun thing is that my parimutuel system, they were describing betting systems that were all either zero sum or negative sum, where there'd be a rake for the operator. My system actually had a add in from the operator, and so could be considered posimutual if that were a word, but it isn't.
Okay.
And so,
Okay. I was like, I think I just heard something. Was that a word? No, that's crazy though. Okay, so instead of a rake, it's an add in. Isn't that kind of the same thing though? Do I not have
um,
my rake definition right here?
well, rake, so like a gambling track, for example, will take in bets on the horses. It then takes that huge pile of money and it takes, say, 10% for its own operating expenses. And it takes the money that's left over and divides it up based on which horse ends up winning and how much people bet on those various
So a pot.
horses.
Yeah, the
Yeah.
pot is going towards the obviously to the gamble,
Same thing
the
if a
gamble line.
casino is hosting a a poker game. Everyone antes in and bets and so on, and the casino takes a piece of the pot as their rake.
Oh, I get it now. Okay. Yeah,
So the rake is exclusively negative, and they never referred to it in any other way than as exclusively negative.
would it ever be more than negative?
Well, in my system,
Well,
since
hold on. Let me
I'm actually
rephrase that. Would it
creating
ever
a
be in the
positive return,
negative? I should say.
uh, not for casinos that want to remain in business.
Okay. Yeah. No, that just threw me off. Like, nothing really could. I mean, in business wise, I guess. But now we're talking about multiple infinities, and so I don't know what's what right now. So go ahead, Noah. You got this.
Yes. So we had to go back and forth a couple of times on those issues. They did dig up another try. There were some meteorologists that patented a technique for hurricane insurance based on betting markets. Um, Essentially, people in hurricane active areas would bet on their own houses to be hit by hurricanes, and that would become a parimutuel pool that would then create an insurance policy so that if your house was hit by a hurricane, i.e., you won the pool, there would be enough money in the pool to pay for your repairs.
It'd
And
be hard to say you won if you got hit by a hurricane, or your house did, rather.
well, that's how insurance works, basically.
No, no, no. I totally get that. I worked in health insurance for almost 7 years now.
There you
But
go.
it's just tough to be positive about that. But
It
it'd be
definitely is.
crazy.
Yeah.
It'd be crazy if there was like a pool like that. Maybe there is. People bet on anything. Uh, so
That patent was abandoned. I don't know that it's actually gone anywhere, but that was another thing that they brought up as potential prior art. So at
okay.
any rate, Um, Late 2019, they they had given up the ghost, and my patent examiner gave me a notice of acceptance. Um,
Okay. This is a good thing, correct?
that's a pretty good thing. So
Okay. Positive momentum.
the next stage of patents, once you get a notice of acceptance, you can take that notice of acceptance, the patent terms for which they've issued the notice of acceptance, put those in, and then they'll give you the patent.
Okay.
There's
So it
a
sounds like you're almost there.
Almost there, yes.
Almost there. Okay.
There's
Okay.
a short time window. If you don't apply for the patent during that time window, then it goes away. The notice of acceptance basically expires, and the patent's been published at that point. So at that point, nobody will be able to patent this.
Okay. And that's for a year, right? That's a year. There's
No,
a year
so
in
the
there
short
somewhere.
term is about 3 months.
Okay. So it could expire within 3 months, right?
Yes, yeah. So
Okay.
if you don't pursue that patent within the time window, it then it will they'll just be like, "Oh, so you're not interested? That's fine. We
Okay.
still have it public, so people have seen it now, so it's not patentable by you or anybody else."
Right. People
And
know about it. Gotcha. Gotcha.
that's it.
Okay. All right.
So at this point, my examiner's supervisor calls my patent attorney, and patent attorneys generally have relationships with these people. That's sort of part of their job, and tells my attorney that there's something going on and that they're not going to be honoring the notice of acceptance. Now, this is rare. There's a procedure for doing this. That's not the procedure.
This is not the procedure.
That is not the procedure. Um, So we don't hear anything else back from them, and we're sort of in limbo. I pay the fee to actually do the application just so that it's in under the line because they haven't been talking to us. Um, and so we put in the application. Um, then uh, about a month after the due date had passed, uh, we get another call saying, "Yeah, that didn't happen. Here's the refund. We're going to have to, get back to you." And a few
Yikes.
months after that, they came back with yet another objection.
Wow. Okay. Wow. That's a
Uh,
lot of it's a lot of things, and they wouldn't call you
yes.
back. They wouldn't talk to you. They wouldn't. And would they answer correspondence then?
No, not really.
Wow.
So
Okay. Wow.
there were a couple of technical issues in the objection, some like commas in the wrong place. So my lawyer said that's not a big deal. We can fix that.
Cross
But
the T's, dot the I's. They got
that
it.
kind of stuff, yes.
Sure.
But the big deal was they were now saying that it wasn't patentable material
It wasn't
uh,
patentable material at all.
at all.
Wouldn't they tell you that at the beginning?
They're really supposed to be, yes, that
Then
should
why
be one of
wouldn't
the
they tell
first
you?
objections. Um,
This would
so
be
that's where
my
that's where the
two
saga
questions.
starts widening out a little bit,
Yeah, I bet.
because what is or is not patentable is actually a floating line. It's not really well understood right now. The controlling law is fairly old, and there's been a couple of Supreme Court decisions that have changed things around a bit. But the last one of those was quite a while ago now.
Okay.
Um, and patents went through a cycle where, in the early days of the computer generation, there were no patents available on software or sort of anything other than physical computer hardware, uh,
Because they never had before?
because they'd never existed before. Exactly.
Just didn't exist. That makes sense.
So, for example, Sun Microsystems, which Eric Schmidt, who was the CEO of Google after it went public, he was also the CEO of Sun Microsystems. They got their start out of Berkeley, and they had effectively designed a completely new operating system and suite of desktop tools on top of a Unix processor. So
Hmm.
when they were going to go form the company, um, the the school, has the rights to intellectual property that's produced under their, auspices while their facilities and so on. So they had a patent attorney take a look at their product, which was a computer, and he had them take the lid off. He looked inside. The chips and everything else were all standard off the shelf components. And so he said, nope, no intellectual property here. Good to go.
To go. Interesting.
So by the time
Interestingly
Google
said.
came along, they
Interestingly.
weren't being that cavalier anymore.
Yeah, I guess not. Yeah, eh, that's its own wildness in itself. Like I was born in '86. Basically, the well, no, the computer came out in like 1980, didn't it? Pretty much the
uh,
desktop computer,
Relatively
roughly.
common desktops were, yeah, late 70s to mid 80s is, depending on what you
But they
count,
were
as relatively
huge.
common.
They were like these massive boxes. Like they weren't like
Well,
a Windows
televisions were a lot
98.
bigger back then too. Yes.
Good point. Good point. Yeah, the TVs were huge and heavy.
Uh huh.
Yeah. Anyway, um, I digress. I'm not here to
So
talk about televisions. Yeah, tell them what happened, man.
so that
Fill me.
kind of
I gotta
stuff
know this.
happened, and it was basically decided that software patents were okay. And so software patents sort of poured out of the tech world, probably far too many. So, for example, um, in the early 2000s, IPM released one of the patents that they had received during the 90s to general public domain. And what they had patented was using a restroom.
Using a restroom.
Yes.
You
So
cannot patent
if
that.
if you've ever used a bathroom, you should thank IBM for, allowing that public domain patent, so that they wouldn't restrict you from having done that. They weren't
What?
actually
Wait a minute.
patenting the process of eliminating in a restroom. What they did was, they were patenting queuing algorithms, ways to line things up and then service a line. And similar to the Lang patent, they patented every kind of queuing algorithm they could imagine, but they patented queuing algorithms specifically for choosing the order in which to use a restroom. And their description of queuing algorithms was general enough that if you have ever used a restroom, you used one of the algorithms that they were describing.
I don't have anything more to say. Uh, I got nothing on that one.
So, at any rate, some Supreme Court cases happened. Some other lower court cases happened, and people started to decide that software patents maybe shouldn't be quite so broad a thing.
Okay, so
Uh,
they started to squeeze in that fence a bit.
yes, and so this
I
day and
see.
age, software type patents um, are specifically allowed under the terms where you're creating a better system or a better thing, um, and that is better at the algorithmic level. And so their claim that
Which is the
my
nanoparticle level for anyone joining us and didn't hear our first interview. It's fascinating.
yes,
Fascinating.
so that's where I was able to again get out my algorithmist hat
Yeah,
and
you know that stuff. You're a
show them
socialist
show them the
for sure.
math about how and why my system actually performs better.
Yeah, and like you're the guy too to do that, which is perfect. I mean, how it's going to be hard for them to fight you on that, I would think. Maybe we don't want to go too far into that
I
discussion,
would I
but
would think
it's
so.
difficult.
Yes, I was able to find actually a relatively famous paper. I talked about this last time. that's actually hosted on a U.S. government server, in which in 1984, one of those home computers running BASIC was able to outperform the task of sorting a million items versus a supercomputer running Fortran,
That's right.
by using a better algorithm.
Yes,
Um,
you did touch on that, and that's wild too. That's you wouldn't guess that if you knew anything about computers. You know.
However, at the same time, another court case has happened, and that is American Axle versus Neepco Holdings. So, American Axle is a company that developed a way to create this sort of uh, cardboard tube to go inside an axle, uh, uh, sort of hollow rod, in order to damp vibration in multiple modes. So if you've got a rod, it's capable of vibrating sort of the way a string vibrates, sort of like up and down, side to side.
Mhm.
Um, it's also capable of sort of twisty vibrating, and it's also capable of sort of physically vibrating backwards and forwards. And so they were able to damp multiple modes of vibration simultaneously by designing this cardboard tube into a very specific helix that would have that property.
That's
So
cool.
they're
That's
a
very
small
cool.
company, and they applied for a patent on that. There's another company called Neepco Holdings, and according to documents that were released during the discovery process, when they saw that patent, they sent their engineering team an email that said, "Figure out how this works and start doing it."
Interesting, indeed.
So they
Okay,
did. And
that's
since Neepco is a big
smart.
company, they had greater manufacturing, and so they were outselling American Axle. So American Axle sued them with their patent, because what a patent grants you the rights to do is deny other people access to your idea.
Hell yeah. Yeah, that makes sense. I mean, that's what I mean. Obviously, that's what a patent is, but
Right.
it's good of you
S-
to reiterate that fact for sure.
So they brought the suit. Um, the judge basically decided that it wasn't relevant whether or not Neepco had violated the patent, but because since American Axle's patent references physical phenomenon like vibrations, it wasn't. It was they were attempting to patent physics in general, and therefore the patent wasn't grantable.
I don't know. None of this makes any sense to me, but I'm following along.
So
And I'll tell you why it doesn't make sense. Because
okay,
you obviously have this great idea, waited all this time. They told you they won't patent you, although they didn't really tell you why. And then they come back 3 months later with a. It sounds like they come back 3 months later at least with
yes.
something a little more concrete. Because then they finally got some
Well,
specialists and maybe
they
another
they
developer
had
to
a
come
reason, but the
consult.
reason was a bogus reason, basically.
See, here's what I'm worried about for you, Noah, is what if someone jumps in front of you? What if someone is doing the same thing or thinking about the same kind of stuff you're thinking about designing and pops in there and is like did put in their patent 2 years ago. So that's within the 3 years. It's that would be
So
the front runner, right? If yours gets
my
rejected.
priority was actually established by the initial patent filing at the preliminary. So if
Okay,
they were did
okay.
it 2 years ago, um, I am
Well, that's
almost 7 years into this process now.
yes. You're. Oof, it's like a lifetime for 7-year-olds.
Yes,
Okay.
or startups.
Or yeah, maybe not all startups or most of them too. 7 years. I mean, that's a good deal of time for sure. Um, yeah, I don't know. Are you? How confident are you that this is gonna that you're gonna storm home? Or are you just winging it, or obviously not
Uh,
winging it, but just not worried about it, kind of thing?
I'm
Or
I'm
what's
mostly
your
just winging it. My attorneys give me
yeah,
3 chances and 4
3 out of
at
4?
this point.
Okay. I should have just asked what are the odds.
Yeah. The the patent office has
That's a good one.
violated its own
Knock on
procedures.
wood.
They have actually made false statements to my congressional office. I asked my congressional office
Ooh.
to look into what was going on, and so they created basically a form letter, which I've been told isn't really what they're supposed to do. But that form letter actually has sort of material statements of fact incorrect in terms of the timeline of what happened.
Wow.
They
Okay.
didn't. They don't mention the first notice of acceptance issuance, uh, which
Wow.
is essentially what they did. Instead of withdrawing that notice of acceptance, they acted like they'd never issued it in the first place.
All right. So they're assholes and they screwed up royally and you caught them. You know
More or
what they did.
less.
Do they know that you know this stuff?
Uh, I believe so. My attorneys made it very clear in the
Okay.
appeals filing.
Okay. Good. Good. Well, power to the people. Power to Noah and his attorneys. I hope it works out well. I think it will. I asked that question because I didn't know if we have to jump off the live stream and have to delete everything. So
No, 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 no. It's
that.
all
So good. Good. No. And you're smart enough to know not to talk about this stuff on a live stream with some dude anyway. So, of the Blind Knowledge podcast, thanks for listening and watching.
so. The craziness that might be going on that might just be causing my thing to go crazy. American Axle appealed their their vacation of patent to the appeals court since they got their patent. They actually wanted to have it, and then they wanted it enforced. So the appeals court basically wrote up something to the district judge saying, we're not going to overturn you, but the way that you overturned this patent implies that maybe things aren't patentable at all. So maybe you'd like to rewrite your opinion, because if you're not allowed to patent things that reference physics, then you're not allowed to patent, things in our universe because
Yeah,
everything
like air.
references physics. Um,
Yeah. Like
so
tension.
so they sent that back down to him, and he took a look at it and wrote an opinion that can pretty much be summarized as, nope, I'm right, it's all fine. Um,
Okay. Ballsy, but yes.
so American Axle then appealed that to the Supreme Court. This is
Wow.
from a couple sessions ago, and the Supreme Court said, "Yeah, we'll hear that filing."
Wait, this was recently that the
This
filing?
was almost 2 years ago now.
Yeah, that's pretty recent. Wow.
So the court um, hadn't gotten it scheduled. The next cycle of the court, which is basically last year's cycle, came up. They didn't schedule it. During this period of it remaining on their docket unscheduled, large numbers of amicus briefs came in from many different angles. Uh, and in this last cycle of the court, they unscheduled it. And so they are, in fact, not going to hear it after all. Um,
When
this
was
is
it
quite
scheduled
rare.
for?
It was never scheduled.
It was.
They said that they would hear it, and then they decided that they wouldn't hear it. This is a thing that happens, though
What?
it's rare. This was also highly controversial, which makes it rarer. Usually, if there's a lot of interest, the court's more likely to step in. But in this case, they stepped back. That means that
Hmm.
this ruling that arguably argues that things that are real aren't patentable is the controlling precedent for patents in the United States.
Okay, so we've gone totally top level. That's so. So now you can't patent things is your argument. I mean,
Well, that might be what the judiciary has said.
it shouldn't even get to that point. They should just do their job and file the right paperwork and not um, leave you hanging. But nevertheless, even if they do leave you hanging like that for so long in time, um,
Well,
there's just so many
so
things that don't add up, Noah. It's just so
yes,
weird.
so
It sounds like you have a cut and dry case. And I
Yeah,
couldn't
yeah.
imagine
Except
anything different.
who knows what judge will wind up in front of and what he'll think about it when it gets there.
Yeah, I mean, when does that happen? Because they haven't scheduled anything yet. So what is the
So
next
mine is not a
step?
Supreme Court trial. I probably have about a year until my case will be heard
So you wait
from now.
another year now that all this madness has happened. You have appealed. You feel strongly about it, and now you got to wait another year to wait for it to
It's
go
a
away.
1 to 2 year wait for the appeal for me, and it's been about 6 months since the appeal was
Oh
filed.
my goodness. Oh my goodness. It's good of you to be so patient. I'd go out of my mind. That's wild.
Uh, I've considered going out of my mind, but it just doesn't seem to be productive.
That's the most honest thing I've heard all day. I'm sure. That's awesome. It's a trip. That's a trip for sure. So does that limit you from talking about the project to working on the project from anything like
Not
that?
not in any way. If the
That's
patent is
good.
ultimately granted, then it'll be granted, and I'll have the enforcement powers. If the patent ultimately isn't granted, then I was never going to have the patent, and I would never have enforcement powers. So um,
Hmm.
I'm doing my best to move forward uh, as things stand.
That's fair. That's fair. You could write a book about this. Literally, this could be an insert. This should be an insert in like a college law magazine or like periodical for
It may
real.
come to that. I've spoken to a number of people who work in the patent space and a number of people who have gotten patents. Having two notice of acceptances denied is not something that anyone has ever heard of before.
Is it? Oof, I don't know. I don't want to get too deep in legalese, but is it illegal for them to do that? Is it just bad business? Is it just unprecedented?
It's possible that it's illegal, particularly
Fair.
by vacating their own procedures. So it might not be illegal strictly speaking, but since they've
That's
since they violated their own procedures doing it the first time, governments government agencies are not allowed to violate their own rules in the prosecution of their duties. Um, and in fact,
fair enough.
civil rights and double jeopardy is part of the appeal that we're making.
Yes, it
Um,
is. I know that part. Yes. Yes, it certainly is. I'm so pumped that I knew Double Jeopardy. It was a
there you
movie,
go.
Noah. No, it was a movie. You know the movie. Well,
Yeah, I
this is
can't actually.
fascinating. I don't know. I don't know what I'm gonna do if I'm you. I'm trying to think. Like, what does Noah do for another 2 years? What are you gonna do? I guess I should ask the man himself. You're right there.
Well, so I've been pursuing a policy of having this be open source overseas because there's no such thing as a global patent.
The
Um,
OBS of market economics.
yeah, you can get patents everywhere if you want to, but the different jurisdictions all count as separate jurisdictions. So you have to go through
Different
each of
countries
those
and such.
jurisdictions patent
Yeah.
processes. There are some streamlines where other countries will recognize that, say, the US or the EU or Japan or other places have well respected patent processes. And so receiving the patent there sort of streamlines the process through their system, but it won't save you fees, for example.
But can
And
you do
so,
business there if it's not patented there?
yes, in point of fact, what a patent does isn't grant you the right to use your idea. It grants you the right to stop other people from using your idea.
Right. Okay.
Um,
Let me rephrase then for better, just as a better question. Would you do business in another country with your product without having a patent in that country?
Absolutely.
You would.
Under any one of several things. In fact, currently, all of the projects that I'm sort of, fanning the embers of are outside the United States.
Well, that in
although
itself.
one of the people I'm working with intends to move to the United States and set up here.
Okay. Well, other than that outlier, I mean, that's so you got a lot of things. You got a lot of cookies in the cookie jars, basically, is what I'm trying to get
I
at. You got things
I
cooking.
certainly hope so. Yes.
That's good. And that's what we need from Noah Healy. We need him out there making algorithms, winning lawsuits, and making the world a better place, one marketplace at a time. Right?
That's what I'm working on.
Yeah. That's what
And
makes sense to me.
and if I can expose the absurdity of the patent system while I'm on the way, maybe that'll help some things out as well.
Oh, it's highly absurd. It was it's so absurd that it actually took you an hour to tell the story about, and you've been in this for years. Like, there's probably so much more too. Thanks for breaking it down for us, dude.
Yeah, there's a long history of patents. There's a lot of crazier things
Oh,
than
I'm sure you read the whole book. I would have. I would have by
yeah.
now, man.
Oh
I would have
yeah.
gone through legal books and stuff like that. For real. For real.
Yeah,
And
yeah.
I'm
I
sure
I
you
did
have, sir.
I did all that almost half a decade ago.
And you smile when you say it. I'm sorry, Noah. I don't mean to push the bear, but or poke the bear. I tried not to yawn, but I'm so tired. I'm so tired of Noah getting screwed. We're gonna try to help you out here, though. Blind knowledge, man. Oh, and by the way, our episode is up on the podcast, like I mentioned earlier, and it's doing pretty well.
That's
Um,
great.
yeah, it's really great, and I appreciate you doing that and coming on, and it's mutually beneficial because we got people learning about Noah and learning about algorithms, and they learn about like what you like, which is cool because I don't know what are coders and computer people. I don't know what to classify it as without going down the wrong road, but like algorithm interest, people with algorithm interests, let's just put it that way. Maybe they've never even knew they had that until they heard my podcast with you on it. So that's so cool.
Uh,
That's what I was trying to get to.
I hope we
So
can reach some of those because
yeah, that's what I'm saying.
it's a valuable way to think about the world, particularly because computers are already ubiquitous and their capacities are only expanding. And so, you know, if you live in an industrial society, learning about motors and how you might be able to use them is a really good idea.
Yeah,
Uh,
definitely. 100%. Could you imagine if we didn't have motors? Man,
it's relatively there are cultures that you can look at right now today that don't have them. And effectively,
really?
what would happen is, yeah,
Well,
there's in fact there's the uncontacted tribes of the Andaman Islands. Um, uh,
oh, I actually know. I think I know where that is. Is that in the Mediterranean by any chance?
no, no, no. That's in sort of the Indonesian chain, like between
Damn it.
like the South China Sea and the Indian Ocean,
Okay.
and they will attempt to murder anyone outside the tribe that they see. And in fact, a missionary I think took a crack within the last decade, and he got killed.
Beautiful way to end this. Beautiful way. We're just gonna end it right there. Oh, I'm just kidding. I actually did. I think I read that same article or an article similar to that where vacationers named off places they would never want to go to. Like
Right.
the
That would be top of my list.
pretty sure that was on that list.
But anyway, yeah, if
Yeah,
motors didn't exist, then the wealth that came from getting engines to do our work for us wouldn't exist as well.
we'd be
Uh,
pedaling.
Billions of people wouldn't be alive because we wouldn't be able to do enough work to create the food that
Billions of
keeps us
people
all
wouldn't be
going.
alive. That's wild. Oh, that
Yeah,
makes sense. The food. Yeah, yeah,
yeah,
yeah, yeah. The plows, the John Deere's,
exactly.
the airplanes.
Just shipping.
It's wild.
We
It's
we
so small,
grow
but it's so
we
wild.
grow a large fraction of the world's food in the Mississippi River basin. A large fraction of the world's population doesn't live there, so we got to get it from there to where people are.
Noah, you should do like here's here's what you need to know today podcast, because those are some awesome highlight points of just random facts that people really maybe would like. I think I liked it. I dug it.
Could
And
be. I
I
think
hope everyone else does too, for sure.
the number one that I always go to explain this to people. Almost everybody's seen the night sky map, that map of the world with the lights of what it looks like if you were looking down at the Earth from space at night. Um, have you seen those?
Yeah, the one with North Korea is dark though.
North Korea is completely dark, and like
Completely dark.
South Korea is like a solid glowing thing, and so is Japan. Well, if you've ever seen what a uh, like map of per capita GDP looks like, sort of topographic maps with like dark blue for rich and like dark red for poor.
Hmm.
Those are the same map.
The same map, really? So the more light, the
Yeah,
more economic.
the more light, the more economic. And the reason why that is because the economy is about physical things in the real world, and you need energy to make things go. And so wealth is a consequence of how much energy you're using.
My man Noah. I don't have anything else to add. Just you're my man, Noah. I am smoking my cigarette, my after show cigarette. Don't smoke. But yeah, I am bamboozled. I have no words. It's onomatopoeia from me, man. Onomatopoeia. Noah Healy, everybody. Noah Healy. There's no stage or applause, and I don't have any plus sound effect. But if I had one, I'd put it on Noah, because it was rad. That was rad. Thank you so much for joining me, man. I appreciate it. And before you go, just gonna lower this funky music real quick. Before you go, where can people find you? Where can people talk to you? What if someone loves algorithms or needs a patent or just wants to hang and talk to Noah for a sec? Where do they go to connect with you?
Well, you can reach out to me directly at Noah P. Healy at yahoo.com. I've got a website at Cordisc, Cordisc, which also has a contact page on it. And you can also find me on LinkedIn. I'm just plain old Noah Healy on LinkedIn. Happy to get a connect. And yeah, if you're interested in having an economy or learning more about the most important algorithms
Yeah,
in the world, reach out.
that's cool. The economy part's pretty important, you know?
Yeah. I think so. And also, if anybody has a crazier patent story than me, yeah, reach out with that one too. Because I
Oh,
think
man.
right now I'm top of the world, but maybe somebody's in even worse
Ah,
shape than me.
yeah, man. If there is any crazier patent story out there, we're gonna need to know about it for sure. If you reach out to Noah, reach out to us at Blind Knowledge as well, blindknowledge.com, and go from there. Then click one of the links. You'll email me somehow. Just you know how to do it. Everyone knows how to do it. Just go to blindknowledge.com, hit the contact us button, and you'll contact me. And if there's absolutely no one in the world that has more crazier effed up patent story than Noah, but if there is, yeah, we're gonna need to have you on too, for sure, for sure. And Noah, if that happens, you gotta come on too, so you guys can debate
Absolutely.
the number one patent guy or woman. Who knows? You're gonna win, Noah. Don't worry about it. All faith and confidence on this end, man. Have a good night. Thanks for
Yeah, you
joining us.
too.
All right, man. Noah Healy, 7 years on a project. Wow, hold on. 7 years on a project, up to 32 months to patent the thing at a time. Ah, man, there's so many numbers, so many scenarios. And we learned that half of the world's supply of food comes from the Mississippi River Basin. So there's that. And how do they move that food? I learned. Obviously I knew, but I couldn't think of it. Oh, machinery and motors. Yeah, my name is Joey B. This is the Blind Knowledge Podcast. I am tired. I am going to leave you here and now. And that's all I got. Have a great night, everybody. I'll leave you with this. We'll see you maybe tomorrow.